Legal Rights Service is an independent state agency. We don't work for the governors, the simplest way to put that. We have an oversight commission of 7 members that are made up of, appointed by the Chief Justice of the Supreme Court and the leadership of the House and the Senate. We are predominantly funded with federal dollars that are called protection and advocacy dollars. We're the protection and advocacy system for the rights of people with disabilities in the state of Ohio. And in that respect, we serve all people with disabilities, not just people with developmental disabilities, which gives us a slightly different perspective, I think, than people who are just kind of stuck in the DD system. Our job is, by law, is to protect and advocate for the rights of the person with the disability. We have about 50 staff now, 16 or 17 lawyers, a number of advocate investigators, and all the support staff that you need to run an agency. The federal grants that we get, the federal law requires us to develop agency priorities, and we have 6 themes or areas of emphasis that we've worked on for the last couple of years. Abuse and neglect, which is a traditional area of our work, special education, kids issues, employment, peer advocacy, and particularly on the mental health side, we're trying to develop a better system of peer advocacy out there. And community integration. As you know, Title II of the Americans with Disabilities Act and the Olmstead decision requires that services be provided to people with disability in the most integrated setting appropriate to their needs. And we have a lot of that work to do because Ohio has a long way to go in that area. Our job as a legal advocacy agency is to represent our clients. And in most cases, that's very straightforward. Our job is to advise them of their rights and where we can, protect those rights, either by defending them in a court action or bringing a court action on their behalf or an administrative appeal or negotiating on their behalf. Frequently in the DD system, we're able to resolve things through negotiation because there's a strong culture of protection of rights going back to Wolfensberger and probably beyond that even. Recognition that the service system should be protecting the rights of the person with the disability from the beginning in the provision of services. So in DD, we tend to resolve those cases through negotiation. Occasionally we'll do an administrative appeal for folks. The fact that the system is funded more with Medicaid now than it was at one time means we do a lot of Medicaid work, a lot of appeals through the JFS system. But our job is to represent the individual, and as lawyers, we have rules that we have to follow that are put down by the Supreme Court of Ohio that define our relationship with our clients. But needless to say, that it usually involves taking direction from the client and implementing their desires with regard to their rights. And the last point that they asked us to talk about is our responsibility to the community in this context. It presents an interesting question, and I think sometimes people think as a publicly funded agency we should be concerned with the broader issues in the community, but because of our mandates from the Supreme Court and our statutory charter, our primary and pretty much only focus is the rights of the individual. Now, that's not as radical as you think, because there's always the buffers of the limits of the law. I mean, rights are defined in certain ways in different contexts. But bottom line, from an ethical point of view, we are responsible to our clients and not to the public, much in the way that a public defender or a criminal defense attorney is. And our job is to make sure that their rights are protected.